Okay folks, good afternoon. It's Alex Woods here, solicitor, posting on the question of just how much is it going to cost me, what am I going to pay, how am I going to pay, and is there a danger that the benefits, any benefits I might gain from instructing you, or any other solicitor for that matter, are going to outweigh the ultimate payment or reward or win that I'm going to get. So I'm going to try and tackle these issues during the course of this vlog. Now, the reason this has come up is because I've had cases recently in the small claims track of reasonably low claim values where it's clear to me that the clients are going through a torturous, sort of contorted process of trying to figure out, do I want to instruct this guy? Is he going to slam me with a large bill? And before I've even started, the costs are going to exceed any likely benefit. So I want to try and address those questions in this vlog. So I'm just going to kind of first start off with how the sort of the paying process works, which is you are going to get an email from me which will quote my hourly rate, and for small claims I reduce my hourly rate by 50% to £150 an hour. Now that, if I have a junior person working on it, that price could come down yet further. Now the reason that I can do that is because I'm not fully representing you all the way to trial, taking on the burden and the duty of being your solicitor and being on the court record as conducting the litigation on your behalf. I'm just sort of slightly standing up to one side, holding your hand, providing you with legal advice and assistance, looking at all your documentation, making sure you've not made any tactical howlers or made any errors in your paperwork or in your understanding of the civil procedure rules. Okay. That's the type of service that I'm providing you. That's good. It's a two-way street. It means that I've got the burden as well as the time, the actual liability of being the solicitor in your case, and I can therefore be a little bit more sleek and streamlined in terms of charging you. When I first look at a case, it's an unavoidable evil. You have to part with some money. You have to part with some money because, I've had people do a runner on small claims and I don't have the time to go chasing them for £150. I need this process to be efficient. So I need you to pay, it could be £150 plus VAT, it could be 3 hours work, £450 plus VAT. Let's use a typical case of £300 plus VAT. I'm going to want you to backs transfer that probably. Now the thing is, that sits on account and it can only be transferred into my personal bank account where costs have been proportionately incurred. Now, so let's use that as a yardstick. Then I may have a look at your case. I mean, let's say it takes me 2 hours to look through all the paperwork, to spend an hour on the phone with you to do a little bit of legal research or something, or gather some further documentation. So let's be realistic here. 2 hours is probably the sort of the range that you're looking at. I can then take a view about whether or not to represent you on a no-win, no-fee basis. Now that could be very helpful to you, and I'm now going to run through some examples just to flesh this out in more detail to show you how no-win, no-fee or contingency fee might work in a small claim instruction. Okay, now let's say your claim value is £9,000. Okay, well let's just round it up to £10,000 for argument's sake, the maximum for a small claim. Now you've parted with £300. I could carry on billing you if you need more and more work, and you really do need your hand holding when you can't go to trial. You need me to be on the phone for any interlocutory hearing, or there's a big load of paperwork in the case. You could proceed on an hourly rate basis, but that you can see those costs go up and up and up and up. And you may then decide you want me at trial, and then costs could really go up. Or we could come to an arrangement, if I think your case is strong, whereby I take a percentage of your winnings. So I say, look, I'm going to take 25%, £2,500. However little work I do on the case, or however much work I do on the case, I'm going to take a risk. I think your case is a strong case, and I'm going to do what's necessary to win victory. It may be tomorrow we settle it, or it may be at trial. So that takes the pressure off you, and you'll know that at the end of the day you'll never be losing more than £2,500. You may well as get the £300 plus VAT back as well if we win. So now in a case of, let's say, £2,000, it may be that it is even more effective, because we take £500. A case is a case. It still needs argument. It still needs a witness. It still needs dealing with the evidence. It still so it's still a piece of litigation. So but proportionality means that in those types of cases we are going to do more work for less money. So in that case, I may charge you 25%, it may be £500, and you may get £1,500. Well, let's say you settle the case before trial for £1,000, you've paid us £500, the claim value is £2,000, you've still got £500. Let's say you settle for £1,500, you've still got £1,000. Now, in that case, you can see how a purely hourly rate basis might simply just not be economical at all, or not something you want to do. You don't want to be paying £150 an hour, because very quickly you'll hit £1,000, let's say, and that will wipe out the claim value, especially if you settle at £1,000, and the whole exercise has been a waste of time. So for high value cases, you might go with the hourly rate for a little bit longer at the reduced £150 an hour, particularly if you're confident that the other side are going to settle relatively quickly and they just need to know that there's a lawyer involved to scare them into paying. Or in a much smaller case, you might want to part with a percentage of your winnings, so it's not going to be a complete waste. Or a blend of both, £150 fixed and then 25% thereafter. Now, in a defence, let's say you're not the claimant but you're a defendant, similar thing would work, except we probably wouldn't be able to offer you a no-win, no-fee contingency fee arrangement, because you're defending yourself against a claim for a sum of money, you're not winning a sum of money. In that case, we would, after the initial expenditure of £300 plus VAT, we would then look again at the claim value, £2,000, £10,000, and once we've spent that £300 and looked at the size of the case, we know what we're dealing with, we can then much more easily fix our legal fees at a certain figure. We might say, well, there's no way we'll ever do more than 5 hours work on this case, so it's a £2,000 claim, that's £550, £750. So at least you're reassured then that you're never going to be out of pocket through instructing us, you're never going to go into the red in terms of paying for your lawyers. Well, I hope that has given you a little bit of a flavour of how it works. Now, just on a little footnote on that final sort of conclusion of this blog, if you get your documents and the story of your case in apple pie order, then I tell you, you will save money. Most importantly, we will then very quickly be able to tell you how much we think work needs to be done on your case, fix a fee for that work so you know what you're letting yourself in for the entire length of the case, or say we think that in this instance you should do a contingency fee arrangement and give us a percentage of your winnings. So get your documentation in apple pie order, and that will be of immense assistance to us both. Final little thing is, someone raised the issue of legal expenses insurance. A client, people have legal expenses insurance on all things now, home insurance, bank accounts, and so on and so forth. So now, legal expenses insurance, sometimes it does come to the rescue like the cavalry. As often as not, it doesn't. If you have got legal expenses insurance, what you've got to do is go to them and ask them the question, will you pay our legal bill? Tell them our rates, forward them the email in which we've quoted you for the case, try and get them to agree to pay us before or at the same time as your instructors. But unfortunately, we can't just start work on your case on the basis that you tell us that you've got legal expenses insurance. And it's a dog-eat-dog world out there. I'm afraid the insurance industry, some of the biggest dogs on the park, and their loss adjusters will attempt to wriggle out of their obligations to you if at all possible. But at least be prepared for that in life. Hope for the best, but prepare for the worst. Any questions or comments, please do email me. It's the easiest way. Email me at info@redwoodlegal.co.uk, info@redwoodlegal.co.uk. I think that concludes today's vlog. In terms of how to pay, I think I've covered that. Backs payment to us on system our client account won't be used unless we do work on your case. We have to refund it to you if you require us to do so. Finally, I am going to do another vlog on preparing your documentation, getting your paperwork in apple pie order in order to make everything that much easier for everyone, including the court and the judge at the end of the day. So watch this space for that vlog. Cheers for now. Goodbye.